Yes.
Adjournment request, if any, from item number 1 to 5.
It pleases the lordship.
Yes.
With the consent of the other side, I'd like to mention item number 5 and 6, your lordship.
5 and 6.
5 and 6, your lordship. I submitted my adjournment slip yesterday, your lordship.
As prayed for on behalf of the petitioner and consented to by the council for the other side. The matter is adjourned to, we have 3 weeks.
Your lordship, can it be on 5th of August, your lordship? In this matter, senior counsel Mr. Bidade, who hails from Tinsukia, your lordship.
Which date would be convenient for you?
5th of August. 5th of August, your lordship.
5th of August would be too early.
7.
Have another date.
7.
Then 17th of August.
7th also would be difficult. There are many other matters. Either you do it today or you leave it to the calendar of the
Yes,
court.
yes, yes, your lordship.
After 2 weeks.
Deeply
Deeply
obliged,
obliged, your
Lord.
lordship.
14. 14.
14. Deeply.
From item number 7 to 11, adjournment request.
No.
Please,
No, no,
Lordship, with the
seven.
consent from the other side, I beg to mention item number 10, Lordship.
Yes.
Lordship, may I adjourn it for a week, Lordship?
As prayed for on behalf of the appellant / Union of India. You're seeking
Lordship.
time on behalf of Union of India.
Lordship.
As prayed for on behalf of the appellant / Union of India. List this matter on so and so date.
21/8.
Thank you. Much obliged.
Highly obliged.
Lordship, after 21, 22,
Then 26/8.
much obliged, Lordship.
From item number 13 to 23. Yes.
Lordship, with regard to item numbers 7, 8, and 9, Lordship, matter may be passed over for the day, Lordship. Angus
7, 8,
Counsel-
and 9.
Yes, Lordship.
Why?
Lordship, Angus Counsel Mr. J. Pine is on personal difficulties, Lordship, so he could not appear today, Lordship.
This death reference matter, no?
No.
Anyway, then it doesn't get passed over. You'll have to take time. You'll keep it on some other day.
Lordship, the matter may be come up on day after tomorrow, Lordship,
No, next week then,
next week.
Monday.
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 4th.
As prayed for on behalf of the appellants, re-notify. All 7, 8, and 9 for in the reference also.
Lordship.
Yes.
Monday.
4/8. 4th of August.
Obliged, Lordship.
May I please, Lordship? But with consent of the other side, Lordship, I am on behalf of the respondent, I beg to mention item number 14, Lordship.
Item number
14, 1/4.
14. Somebody has to mention in 13, no? Slip has been circulated.
13 and 14.
Yes.
For 13.
Item number 13,
Yes. What do you want?
Lordship, adjournment. We have
What?
submitted the adjournment slip.
For how many days? You're for
3
whom?
weeks, Your Lordship.
You appear for the estate.
Petitioner, yes, Your Lordship.
As prayed for on behalf of the petitioner. That's state. As prayed for on behalf of the petitioner state, I mean.
No.
As prayed for on behalf of the petitioner, re-notify after 3 weeks.
26/8.
This is by retired judge.
May I please, Lordship? Lordship, I beg to mention.
Item number 14.
Lordship.
Yes.
I'm for the respondent, Lordship, matter may be adjourned for
No,
3 weeks.
have you taken consent from the appellant or the petitioner? Appellant.
I have taken consent, Lordship, from the appellant.
You have. As jointly prayed for, re-notify on so and so date. Yes.
May I please, Lordship, I beg to
28.
mention item number 23, Lordship. I've taken the consent from the other side, Lordship. Lordship, the senior counsel is out of station, Lordship, hence your Lordship may kindly adjourn this matter.
23.
Yes, Lordship, for 2 weeks.
As prayed for on behalf of the appellant, re-notify 2 weeks.
Highly obliged.
21/8. Any other request? Supplementary list for admission, item 24.
Supplement. Start with item number 24. You start with supplement. Yes.
Your Lordship.
Yes.
Lordship, my senior is on legs. First, kindly pass over the matter for the time being.
Ask him to be here tomorrow. Shall be listed tomorrow. Who appears?
Mr. S. Vidas.
All right.
This is the.
Ask him to be here tomorrow.
Okay.
Item 25.
Yes.
May I please, Your Lordship?
Lordship, here my whole case is that, Your Lordship, I have a home loan, Your Lordship. Home loan has been sanctioned in my favor, Your Lordship. It is 40 lakhs rupees, Your Lordship. Now, Your Lordship, however, I defaulted 13 EMIs in that home loan, Your Lordship, for which, Your Lordship, my account has declared as NPA, Your Lordship. 8 February 2023, my account has been declared as NPA. After that 13-2 notice, Your Lordship, 13-4 notice, subsequently my secured asset, Your Lordship, has been taken over possession by the bank authority, Your Lordship. Now, Your Lordship, after initiating the proceeding, Your Lordship, under SURFACE Act, Your Lordship, the son of the petitioner, the borrower, Your Lordship, approached Deputy Tribunal Guwahati, Your Lordship, for the proper relief, Your Lordship. Now, Your Lordship, that order is at page number, Your Lordship, 60, Your Lordship.
61.
60, Your Lordship.
You want to refund
60, Your
the
Lordship.
amount of the gain of fund.
Here, Your Lordship, my prayer, Your Lordship, my limited and my only sole prayer is that, Your Lordship, as my account has become NPA,
Mm.
I'm still in active mode. I am paying the rest of the EMI, except the 13 EMI, Your Lordship. I am paying the rest of the EMI. My account is still active, Your Lordship. 66 EMI still left there, Your Lordship.
Mm.
My prayer before the DRT, Your Lordship, to upgrade my NPA account, Your Lordship, to standard asset, Your Lordship, as per RBI, as per Master Circular, Your Lordship, issued by Reserve Bank of India, Your Lordship, clause 4.2.5, Your Lordship.
This order will be also appealable.
No, there is an activity.
Have you filed an appeal against this order?
Appeal, Your Lordship.
Appeal.
That has been
Appeal also dismissed.
dismissed, Your Lordship. Because, Your Lordship, why I'm saying regarding the maintainability, Your Lordship, I'm Lordship on that, Your Lordship, because my prayer here, Your Lordship, not to, Your Lordship, interfere the section, proceeding under SURFACE Act, Your Lordship. There is not a single whisper in my writ petition, Your Lordship, whereby I have challenged, Your Lordship, the proceeding under SURFACE Act, Your Lordship. My only prayer, Your Lordship, due to not abiding, Your Lordship, the clause 4.2.5 of the Master Circular, Your Lordship, I'm providing that circular, Your Lordship, issued by Reserve Bank of India. Because of this, Your Lordship, this petition has been filed, Your Lordship.
The petitioner, a loanee, seeks upgradation of the NPA of the petitioner against the loan account number so-and-so to a standard asset on the promise of making payment of all areas outstanding, along with the interest as on date against the aforesaid loan account, which also is in consonance with the provisions contained in Master Circular dated 2/4/2024. This prayer was made by the petitioner before the DRT, which was rejected, and the appeal against such rejection also got dismissed. The contention of the petitioner is that there was a default in the payment of 13 EMIs, but presently the EMIs are being paid regularly. First off, even prior to the default, all the EMIs were paid. First off, the petitioner only desires that it should not be the mortgaged property should not be converted into NPA and should be upgraded as standard asset, with the assurance of the petitioner that the loan shall be amortized in the phased manner. Let notice be issued to the respondents on steps being taken by the petitioner within a period of 2 days, both modes, returnable on to give after 2 weeks. Take 3 days so that you file requisites properly, returnable 3 weeks.
Subsequent proceeding may be stayed, Your Lordship, with due respect, Your Lordship.
Proceeding.
The auction is going to be held, Your
In the
Lordship.
meantime, the respondent shall not take any coercive step.
Lordship. Much obliged, Lordship.
Then we keep it 2 weeks only. Returnable 2 weeks.
And they can serve dusty on the regional official.
The respondents, the respondents can be served, the respondents be served thusly as well, for which the petitioner shall file requisites in the office, and the advocate for the petitioner shall be given a copy of the notice to be served on the respondents.
Highly obliged.
Respondents notice to response number 4, 7, and 8.
Highly obliged, motion.
On 18.8. Daily list for hearing, item 1.
State reserve. No, this is against the encroachment of forest lands. 8 reserve forest and 1 wildlife sanctuary towards the northern bank of the river Brahmaputra. Now, all of these have been admitted by the respondents. And if your lordship would kindly peruse the last order, 4th of February, they were directed to file a affidavit providing the road plan.
Was to be submitted by the court.
Yes, where is Mr. Gogoi?
Yes, my lord, we are seeking 2 more weeks to file affidavit. A plan is being prepared. for
That has been continuing for a long time.
One more opportunity may be given, my lord, really.
But Mr. Gogoi should have been here, no?
My lord. He's on his way, my lord.
All right. Again. This public interest litigation is aimed at securing removal of encroachments in the Sonai, Rupai, Namedi forest landscape in Assam. The petitioners are spirited bodies. The petitioners are the NGOs who have, in the present case, highlighted the violations of the forest and wildlife protection laws, causing ecological damage and human-animal conflicts. The core concern of the petitioner here is the encroachment of the forest land. It appears that on an earlier occasion, this court was informed that a roadmap has been prepared by the Department of Forests for removal of encroachment from the forest area under the said landscape. Mr. What is your name?
I bought it.
Mr. Bothakur, learned advocate submits that necessary instructions have been received, including the roadmap framed by the government, and the same shall be brought on record by the next date positively. Let that be done with a copy served in advance to the counsel for the petitioner. List this matter under the appropriate heading on after 3 weeks.
28. Item 2 and 3.
Yes.
Lordship, this matter has been listed after more than 1 year.
After more than 1 year.
Yes, Lordship. And it's an old case, 2018, and the issue relating here is that encroachment in the forest area.
Yes.
We have submitted 2 affidavits already, but for last 3-4 months, Assam is on a mission mode to clear all the forests. Even today, 2 forest reserves are being cleared. Last week also in many places.
So this.
So I would like to place a phased affidavit giving the up-to-date status.
All.
Well, I am appealing for the
And
state of
also regarding
Mizoram.
the Mizoram issue also, there are some developments which also I would like to bring to this honorable court's notice.
Yes. Yes, somebody.
I'm appealing for the state of Mizoram, my lord.
Yes.
My lord, subsequent to the order which was passed by this honorable court on 8th of August 2024,
Yes.
there was a meeting, my lord, on 9th of August. My lord will come to, kindly come to page 340, running page 340, my lord. A joint statement was issued, was signed and issued by the government of Mizoram Lordship has got it?
Just,
Running page 340.
yes. Now we have got it.
Yes. It was a joint statement which was signed between the government of Mizoram, represented by the Home Minister Mizoram, and the government of Assam, represented by the Minister of the Border Protection and Development Department, Assam.
Page 340 is the 5th page of some affidavit. Is that correct?
It's a
This affidavit on behalf of state of Assam?
Yes, yes.
Yes. So which paragraph, which number, which paragraph are you referring to?
I'm referring to page 340 of my affidavit.
340 of your,
Been filed by the affidavit which has been filed by the state of Mizoram, my lord.
no, then perhaps your paging is incorrect. We'll have that confirmed. But tell me, read out that paragraph.
It's a joint statement, my lord. It is reaffirmed that the goodwill mission between the government of Mizoram and the government of Assam, held on 9th August 2024 at Aizawl, Mizoram, is to take forward the firm commitment and the initiative made in the meeting on 9th of February 2024 between the Honorable Chief Minister of Assam and the Honorable Chief Minister of Mizoram for resolution of the interstate boundary dispute in an atmosphere of understanding and goodwill between the two states. Both the states agreed to continue to promote and maintain peace and harmony and prevent any untoward incidents along the interstate border. Shall I proceed, my lord?
Yes.
Joint cultural and sports festivals may be organized at frequent intervals by concerned administrative authorities of the interstate border districts of the Mizoram and Assam to start before 31st of January 2025. Both the states reaffirmed the decision of the joint statements of all the previous meetings to arrive at an amicable resolution on the vexed border issues. It has been decided that all pending discussions and decisions to be made on the issue and other connected matters shall be taken up by officials of both the state governments. This will be followed by a series of meetings to be held.
That's right. That's right, Mr. Dev. We have followed that.
And then, my lord, on 25th of April, there was another meeting and official level talks between the Assam and the Mizoram government.
All right. Who appears for
is there? You will
all right, Mr. Dev, it's all right. Who appears for Nagaland?
I appear for my Nagaland, my lord.
Mr. Balgopal, yes. What do you have to
Please,
say?
my lord.
Yes.
My lord, here, as far as Nagaland is concerned, the issue is slightly different in the sense when the petitioner filed his present petition, they had not taken note of a pending suit in the Supreme Court pending since 1988.
Yes.
Now, the only point I want to point out is that in that very suit, since the encroachments are supposed to be on the reserve forests, we have got notifications from time to time, pre-constitutional in nature, by which these tracts were slowly transferred to this Assam province. It was not a state at that time. And Nagaland was not a state either. Nagaland was part of the Assam province. So on this issue, several such forests have gone. So I would only make one suggestion subject to your lordship's approval.
Yes.
Because we don't want to get into that border dispute here, because the appropriate court under Article 131 is looking into it.
Yes.
So the issue being limited to maintaining the environment, seeing that no damage is caused, and to get into something very effective. From my past experience, I think we need a high-level meeting first of the officials concerned of both the parties. These things have taken place in the past, even in border disputes, so that we can thrash out and minimize the areas on which we can look into it. Because once they say that we have encroached into that area, then our defense would come. We don't want to get into all that. We want to see that the environment is protected, and I think nobody can have any objection to that. So if your lordship feels appropriate, we will also sound the state of Assam on this and try to convene a proper meeting so that the areas of dispute will come down. And ultimately, this may result in a positive solution. Instead of saying that this is mine and that is yours,
All right.
we may not
That's,
find anywhere
that's
else.
that's very positive attitude of you. And
Yes.
what you're saying is being heard by the Advocate General of Assam. And I suppose he also does not have any problem. He
What
says-
my learned senior friend has said, the Advocate General of Nagaland, I would like to add something more. Today, one of the eviction drive is done in Negheriting in Golaghat district, which is having border with Nagaland. So for last 15 days, there were 2 rounds of meetings with the Deputy Commissioner of Golaghat and the bordering district of Nagaland. And there is an understanding that eviction can be done or encroachers can be removed from that area, which is also under dispute, but the area which is within the state of Assam and where there is no difficulty, it is going on. Only concern the Nagaland is showing that nobody who are evicted from these places because they are having all doubtful citizenship or something else also. I do not want to make any comment
No,
on
no,
that,
don't.
but they should not enter Nagaland. That is the only concern of Nagaland at this stage. So we are removing some of the encroachment in Negheriting, which is bordering
No, no,
Nagaland.
but can you not have a meeting with the
The meeting is going on, Lordship.
meeting is going
Meeting
on?
is gone. That's
So
why
resolve
a
this.
protocol has been set by the Nagaland authority and our authority of Golaghat district, and is an understanding on
Look
that.
at this now. Border dispute shall continue. It shall be resolved in a different forum.
Lord.
No difficulty.
Absolutely.
But
Lord.
so far as clearance of encroachment in forest
Absolutely, we are
area is
doing it,
concerned,
and Nagaland is also helping.
Nagaland wants this to happen. Mizoram also would not lag behind, and Assam has the responsibility to have it cleared. Because otherwise the whole purpose, the whole mission gets frustrated.
So far as Mizoram, the issue was little bit different, but now it has come down. We are in
Ask the
understanding.
3 states to
No,
have,
Mizoram already had several rounds of meeting, my lord.
Absolutely.
that's right.
And now things are
Several rounds of meeting, Mr. Dev, only suggests that things have not been concretized. Now, let you have a final round of meeting with the resolution signed by all of you so that it goes into action. Now, several rounds of meeting will continue happening and encroachment would continue to stay. So
no,
that
all these meetings have a positive outcome, my lord.
Now,
That
can
is
I
what I
su-
want to submit, my
Can I
lord.
suggest all 3 learned advocate generals to have a final meeting, jot down the resolution and proceed ahead with with the responsibilities earmarked for each of the state. I mean, the government of Assam shall carry out the work with the support of the government of Mizoram and Nagaland. Is that correct?
I fully appreciate this suggestion, Lordship. I am more than happy to do it because one of the area between Assam and Nagaland is called Inner Line Forest, Inner Line Reserve Forest. That is the area whole. It is about more than about 300-400 kilometers border, covering 3 districts of Assam, and where the major issue cropped up. And there we wanted to set up a commando police battalion, and there were some issues. Ultimately, the learned Green Tribunal of Delhi, the capital, the central bench, they have cleared us, and now we have started the work. So for that also, if Mizoram is cooperative, that will be more than good for the whole issue. For
I will
protecting
make-
the inner line forest.
All right. So,
I would like one submission with your lordship's permission, my
yes,
lord.
yes.
As far as the meeting is concerned, these meetings are at the district level. The meeting should be convened at the level of the chief secretary and the connected officers of the department. And from my past experience, as I was mentioning to your lordship, it may not be over in one meeting and they will not pass the resolution because this is a very sensitive matter.
All right.
I would only suggest let us have a first meeting at the top level.
Yes.
And because even now both the states of Nagaland and Assam, they
Yes.
also enjoy very good relationships even at the political level. So many things can be sorted out, my lord. So if it starts at the chief secretary level, something concrete can come out.
All right. That is what I suggested in the beginning. And in fact,
Very well.
that's
I'm
the
ready.
need, that's the need of the hour. Take note. We have heard the learned advocate generals of Assam, Mizoram, and Nagaland, all of whom are ad item on the issue of,
Arunachal is also there.
yes, who appears for Arunachal? Yes. We have heard Jubia and so. What is your name? A. Chandran for the Arunachal State Administration, Arunachal Pradesh State Administration. It was very heartening to note that all these states are ad item on the issue of the importance of clearance of the forest area of all encroachments. It appears that several rounds of meetings have taken place between officials of the states to come to a consensus and build a roadmap for eviction of for making the forest encroachment free. There are some issues which are plaguing complete implementation of this mission, namely certain litigation pending before the Supreme Court. There are some contentious issues with respect to the occupation of people in the inner line forest area. First up, this court believes that nothing can remain unresolved with a dialogue, with a fruitful dialogue. First up, it was acceptable. It is acceptable to all the learned advocate generals of the states to have a high level meeting convened comprising the chief secretaries and chief of the forest departments of each of the states and other relevant stakeholders for coming to a for formulating a plan for making the forest area encroachment free. We have also appreciated the stand of the states in not bringing here any issue regarding border dispute, any issue relating to border dispute between the states. Border disputes would be resolved, but before that, what is of utmost importance is that the forest area falling in the territorial jurisdiction of the states ought to be removed of all encroachment, if at all the states are serious about such issue and that they would be interested. First of all, this would only be in compliance of the Supreme Court judgment. First of all, without making the entire forest area encroachment free, the biotic pressure cannot be eased. We hope and expect that by the next date, this court would be informed about the resolution passed by the high-level committee about which reference has been made in the earlier paragraph and its implementation on the ground. First up, we would appreciate if all the states put in their response affidavit stating the part of the responsibility which they would be discharging after the meeting and after the resolution to that effect is formulated. First up, list this matter for further consideration on. We give you 3 months' time.
Very well. Deeply obliged.
Re-notify on so and so date. 3
Deeply
months.
obliged, my lord.
Deeply obliged.
Deeply obliged.
3rd of November.
Lordship, in this case, I am for the appellant. It's a private case of Mizoram government, Lordship.
All right.
So
Which is the
Item 4.
Item 4.
4? Yes.
So I'm praying for short accommodation, maybe day after tomorrow. I have to appear in a presidential reference matter of Supreme Court online, Lordship,
Oh.
which is going on.
Please, Mr. Saikia.
Lordship.
At the instance of the learned advocate general Assam, the matter is adjourned to which date?
Could it be next Thursday?
Next Thursday.
Not to day after tomorrow, after that.
7-8.
Next Thursday.
Next Thursday.
Highly obliged.
At the cost of interruption, my lord,
Yes.
at the cost of interruption, instead of 3rd November, if I could have 6th or 2nd November, subject to your lordship's kind convenience.
I
3rd No-
couldn't hear you.
I was saying that if it's not inconvenient to your lordships, instead of 3rd November, could it be 5th or 4th or some date after
Yes,
that?
yes, fourth, yes.
Fourth, yes, yes.
I'm
Oh.
grateful.
We would not be inconvenienced. We are always here. It is your convenience, which is it. 4th of November.
I'm grateful.
Highly obliged, Lordship. The matter relates to that governor's power within 3 months, whether that bill should be.
Oh,
That is very interesting.
all right. No, this was, this item number 4 is next Thursday, no?
Yes.
No, Lord, 7th he's saying.
That is,
No, fourth, he's proposing 7th.
4 I have thought adjourned.
7, 8. This, Mr. Balgopal was mentioning.
The first 2,
So that is,
2 and 3.
yes, as whatever is.
Highly obliged. Lordship.
Item 11 and 12.
Yes.
Yes, Your Lordship. Before starting this entire matter, Your Lordship, I will just put into some of the bullet points that why this matter is very important and sensitive as well. So after
No, you need not impress from that. The matter is important. It is sensitive as well.
Yes.
You have to formulate the issues.
yes, so before coming to the issue, some of the bullet points are very much important.
All right.
That after that, India got independence in 47.
Yes.
When the need felt that India should have a separate constitution and the constitution assembly debates were going on, many laws were formulated or were put under the paradigm of the constitution. But it took 65 years when for the first time, the division bench of the Honorable Supreme
Can
Court
I
came
have your
and
name? Can I have your name, please?
Swati Vidhan Barua.
So, all right. Can I, counsel, can I request you to avoid that, legend?
Yes.
You just come to the issue. We are aware of all such issues.
Yes.
You can trust us. We understand the
Definitely.
problems. We understand the difficulties. In
Yes.
fact, we have been able to alleviate most of the problems faced by transgenders in my
Yes.
state. We are aware of that. Now you tell us, what are you aggrieved by? I am not cutting you short. We are only limiting the argument.
Yes.
See, if you can tell me the legend that you want to say within 10 minutes, all right.
Yes, within 10 minutes.
Okay. Okay, then I allow you uninterrupted argument.
Thank you. Thank you. Blessed. So after that, it took 65 years when within this 65 years, when the normal gender binary norms, they enjoyed the various rights as well as the democratic rights, who were subjected to be termed as the born criminals under the law, which was known to be as the Criminal Trial Act 1871. And after that, it took 65 years when for the first time, the Supreme Court came in font and took up the petition of Nalsa. That is in 2014, 15th of April, the landmark judgment came, recognizing the various rights. After that, the many direction was given to the center as well as to the state to formulate various policies pertaining to the development and upliftment of the transgender community at large. Many states are still, they are silent. Some of the initiative that has been taken by our state. In the meanwhile, then again, this Navtesh Singh Johar judgment came. So when for the first time, the constitutional bench said, history pays an apology to this community. And after this, even though how these discriminations are still going on in our state, that your lordship may see in PIL 6, page number 72.
Yeah, 6.
We are in IE also.
Your things. Next, please. Yes, page.
6, page number 72. If your lordship has found,
Yes.
it's an annexure 4. It says recruitment for 320 male and transgender, 314 post and female 6 post for sub-inspectors AB arm branch for newly created Assam Police Commando battalions.
72. 72.
72, yes.
Page 72.
Hmm.
So this was for the first time an advertisement was published
Hmm.
where they have the separate evolving principles for the female, but the discrimination comes when they collab the trans communities with these male persons. And they set up the criteria. And by saying in many of the dates, the other side was keep on saying that no transgender has applied. But how will we apply? Because there are no any certain evolving principles, no separate criteria for us. We were being collabed with the male. Now, many trans person who has undergone surgery from M to F or F to M, they may not fit in the criteria which has been set up in this advertisement.
Now tell me one thing, if somebody gets operated
Yes.
and turns into a female or a male,
Huh.
then which category applies to them?
The Supreme Court says either male, female, and third gender.
No, third gender is when there is no, when the features are not
Yes.
very discernible.
Yes.
But once you get operation, once you have
Then comes within the binary male or female.
binary
criteria.
male.
But here,
is that correct or something
yes,
else?
no, it is correct.
Hmm.
It is correct. It has already been recognized by now WHO.
Hmm.
Now, previously
Now,
it was
therefore-
known to be as
therefore-
gender.
Collating it with males,
Yes.
how does it offend you?
It offends. Suppose I am born physically as a male.
Hmm.
Later on, I got converted into a female.
Yes.
Then how will I be able to compete with these male candidates?
Ultimately, you will have to fall in the category of a female. What
Female.
you are,
Female.
what you are today.
Yes.
So
but-
therefore, there would be some collating of female with female candidates.
Yes. So, but here the
Therefore-
trans has been entirely collabed with the male candidates.
No, that's right.
So the same
Makes
thing.
sense to us.
Yes.
Then
Now the
let's
same
see the
thing.
females.
Yes. Now the same thing at page 89. Here also, if your lordship has found
89.
page 89. This is again a recruitment process
Hmm.
where for the post of 2,450 post for commando battalion constables. Here also the same thing has happened. The male has been collabed with the trans.
Hmm. Who represents the DGP? What have you done about it?
My friend, Mr. Dinath, senior government advocate, is on the way. Lordship.
Have you filed any affidavit?
Lordship.
Have you filed any affidavit?
My lord, Mr. Nath is handling the case.
And that's true.
We have-
We will wait for Mr. Nath,
Yes,
but
yes, my lord, they have filed.
they have filed an
They have
affidavit.
filed.
Where is that? Can you tell us?
Is 130. 131. Just file 21 for 20. By the.
Just.
Is it not? Page 147. that was leadership first.
This application does not clarify. We'd like him to explain. It's a very simple issue raised. I mean, it has to be thought of.
May I pray, my lord, I am not
You're not
I don't-
aware of it.
aware of it, my lord. His legs, my lord, that is why, my lord, problem. I have asked my friend to.
Now,
my-
now interestingly, what
May I pray,
happened
my
is,
lord, for the time being, it is with my.
I is just. Swati. Swati.
They had 6 record of claim of that. He handle কৰি আছে তো মই বহুত ফোন। অলপ পিছত হৈ গ'ল আজিকালি।
You're Swati.
yes, your lordship.
Can we put it on some other day when the lawyer is here? Now we have to put it to him that what is the mechanism
Now,
by which.
now your lordship, another important surprising fact in this matter is this advertisement came in the year 2021. Whereas there was a new enacted law, Transgender Act 2019 came into existence.
Now, what happened to this advertisement? Have the recruitments been made?
Recruitment made, appointments has been given, and all the applicants, they are now working. But we have missed the bus. We have many times asked them, trains and flights are available to accommodate us. Never, we were done that.
As transgender, those who have not got any opportunities, whichever category they fit in, they can apply. I think would that collab have been better, that whichever category the transgenders fit in, they
Yes,
should apply?
yes.
Whether
But that
male
is
or
also
female.
absent. Yes.
Notwithstanding any operation or anything, if nothing
Yes,
is there, then
but
by
that will be
where
again
would where would they like to be put?
But that will again be guided by section 6 and 7 of the Act, where transgender ID card and certificate issued by the concerned district magistrate.
I will hear it on some other day. Now the urgency is gone because the recruitments are over.
Recruitment
To-
over.
To sort of restrain the government for the next recruitment drive, not to do this.
Yes,
The matter has to be argued. Let us.
but there will be another angle into this aspect is, suppose the transgender who couldn't apply and they have crossed their age limits. What will happen to those?
Nothing can be done about that. You know about the service jurisprudence.
So that is why
So
many.
we would pull them up. We will think about the necessary course of action, but then nothing can be done. We can't create posts.
But that is why many high courts has now taken this matter, and now they has been directed the state government to create 1%. Some state came up with 1% reservation. Some came with 2%. The recent Karnataka High Court came up.
That we cannot ensure, but we will definitely have you placed in the category where you can compete with people.
Yes.
So that you have equal opportunity. Reservation, yes.
Then
that is for the union government.
competing will be in another aspect. Then the second aspect come the medical criteria, that how the medical process will be conducted.
They have
So
to
then
come up with
again,
clarity.
yes.
Anyway, Mr. Nath is appearing.
Mr. Rathi.
Ask Mr. Nath to be ready on all these. You have heard the argument.
Yes, my lord. On that
Bring,
point.
apprise him of this
My lord.
and ask him to be here. It's an important matter. It's a
Yes.
sensitive social equation matter. It has large repercussions. They need to be, I mean, the transgenders who can deny that they are part of us?
Yes.
And they have to be incorporated in the mainstream. And you can't possibly do that if you don't provide avenues to them. Right?
Right.
So these are issues which need not be elaborated upon. Let us find out ways in which they can be accommodated, made part of the mainstream seamlessly without any difficulty.
Therefore,
Yes.
recently the National Human Rights Commission also passed out a directives to all the state. But even that is not yet
Please
implemented.
compile all such
Yes,
directives.
it's all are there on the record.
On record is something else.
Yes, I will compile. I will compile.
Convenience volume.
Yes,
So that you can refer from it.
yes,
It'll be easier for us. It'll be easier for the other side.
yes.
And I see that you're very well prepared about all this. So I think we should take some help from your hard work. You make a convenience volume for us. All the necessary judgments and documents that you want us to see for us to appreciate. Though we are appreciating your arguments, but then
Actually, your lordship just want to take 2 minutes. So actually this NALSA judgment, how this came into existence. So at that time, I was not into the field of law. So I was just attending one conference and the Honorable Justice CJI, Dadan CJI, Altamas Kabir was sitting next to me. And then when we were discussing with my other trans activist friends, so he was asking me, Swati, what are the issues? So I elaborated him, and when he was called on the dice, that time I came to realize that he is a CJI. So after 6 months, this NALSA came to be filed from the National Legal Service Authority, and this judgment was decided by finally the division bench of Justice Radhakrishnan and A.K. Sikri.
we'll see this. Swati Vidhan Baru, a learned advocate, has appeared in this matter and has raised arguable points with respect to treating all transgenders akin to male counterparts for the purposes of recruitment in police service. It has been argued that in accordance with service, Mr. Nath, learned senior advocate, appearing for
The state.
appearing for the state, Nath representing state, is in some difficulty today. Let this matter come up for consideration. We put it after 15th of August. Sometimes in late August, on a hearing day.
Your lordship may just fix it up after 20, because from 15th, most probably my next PI will be going to be listed in the Supreme Court.
Okay, so we keep it in first week of September?
Yes, no issues.
First week of September.
Also, your lordship may take a note on that PIL 2. The same fact, but a little different. Where as per the Act and as per the Assam state policy, the state government was required to constitute a committee or constitute a board, Transgender Welfare Board. Even though that is constituted, but there is no such office. So in case of an emergency, if a transgender is required to approach anyone from the welfare board, that the welfare board office is all the time, 24/7, it is locked. Now they files an affidavit saying that in absence of any of the members of the transgender welfare board, the community can go and approach director. Whereas director has got no locus as per the state policy. Only he is just a member secretary, and he will be taking care of only the funds and finances and arranging meetings. So in that case also we are suffering, the community is suffering.
All right, we'll look at it on that.
Regarding this community. This constitution, but they want no petition.
There's no place where the committee will sit.
No place. The meetings are going on in either in the minister conference hall, even though they have taken an office on rent. But I will produce a videography of that. That is locked till date.
I'm waiting for the government department in PIL.
All right. Oh,
Next case.
this next case also.
Next
So this informs the next case.
This also will be listed.
Let's say, no.
This case also shall be listed along with that case on that.
Yes, it's a tag matter.
Already.
4th of September.
Deeply obliged, Your Lordship.
Obliged.
Item 15.
May please your lordship.
Yes.
Well, this matter is with respect to the constitutional variance of 43D5 of the unlawful activity.
What 43D5? That has been decided long time back.
No, my
The
lord.
constitutional validity is pending before the Supreme
No,
Court,
no.
but otherwise, just listen to it.
My lord.
Now, Zahur Ahmad Watali, Supreme Court decided it in 2019. 2021, K. Najib. They say that it is constitutionally valid for the reason that the constitutional courts have the authority to override that provision. And it is under question. I don't know whether
I've
you are
appeared in
aware-
the Supreme Court in this matter, my lord. Supreme Court, Honorable Supreme Court has referred this matter to the concerned high courts.
Where is that? Where
My
is
lord,
that?
this is the order.
Where is the referral order?
Yes.
Let's see, let's see.
Page 5. Page 5.
Just a minute. We proceed, but then we'll see what is. Let's see what has happened here.
This page 5, we
Give us the current status of the case.
this matter. The present status was what happened is that I've been told that the government of Assam has passed a circular that all these matters pending before the NIA court in Assam, special court, that will be taken over by the state of Assam. And those cases has been shifted to district courts, concerned district courts. Concerned district courts. But the issue which, as far as I am concerned, your lordship, is that very simple issue. Thing was that if you read 43D5, yes, your lordship is correct. I agree to that, what K.M. Nazib Sawatali has said, that constitutional courts can read down. Constitutional courts, there is no embargo, they can go. If they have inordinate delay is there in the trial. Yes, by Article 21 and 21. Now, question is that if we read 43D5, here the two phases are there.
Now we are aware of that argument, Mr. Borgohain.
That case diary
We
and
are-
charge sheet.
We are aware of all that argument. Now you tell me whether Supreme Court has decided the matter or not.
No, my lord. Supreme Court is not
We'll,
decided.
we'll await the decision of the Supreme Court.
No, Supreme Court is relegated, my lord.
That's with respect to different thing.
No, your lordship, kindly come to page 5.
We have read that.
Page 5. The High Courts may proceed with writ petition challenging the provisions of the UAP.
It's a constitutional value.
My lord,
Who appears for the state?
I'm
appealing for the
union.
Union.
Yes.
Get ready in the matter, we'll hear. And tell us the status. I mean, I don't think the matter requires to be heard. This issue, this was a writ petition, I don't know. The otherwise also, when the first order says that Delhi High Court Chief Justice would be required to send all the matters to division bench, that means the virus was never challenged. What was challenged here? We would like to have the writ petition.
I have copy of the writ petition.
You
I have the copy of the, there was the Sajal Avasti was that a single designation of a person as terrorist organization. That is amendment in 2019 that has been put to challenge.
How do you say that it's the same issue as that of 43D5?
My lord, one of the writ petition they have raised this issue.
Give us the copy of that writ petition.
My lord.
memo. Mr. Borgohain, you must understand that we are very, very cautious. Therefore, please do not make any statement which has the potency of misleading the court.
No, my lord. I will tell your lordship
The
why.
last occasion also, I must tell you, we are very straight.
My lord.
This court believes in, nurturing and mentoring lawyers.
My lord,
But if you ever try to hoodwink us, we come down very heavily.
my lord, your lordship will bear with me for a moment. They filed the affidavit.
We have only cautioned you. If you want to take hint from this, all right.
My lord,
Just don't rattle out cases of Supreme Court and other cases. You must tell us. I mean, I don't think this issue is been relegated to the High Court to decide. And you're asking, we will not do that. Let me see the petition.
my lord,
And be very careful in making your submissions.
my lord,
We are absolutely cautious. We can't get swayed by unnecessary arguments.
no, my lord. Kindly.
See, this is the second time that I am hearing you. On the last occasion also, I found that your arguments were capable of being misunderstood and the court being misled. Therefore, we are warning you. I don't take it otherwise. We are only cautioning you that you be very, very careful because we depend on lawyers.
My lord, your lordship will kindly see my application that will clearly demonstrate that I have approached the Supreme Court on the instruction filed by the central government. Kindly see my IA, my lord.
Additionally is paid for it. Additionally is paid for it. What is it, Lord? Look at this. This referral, how do you say that this is for the, this has been referred for deciding the virus of 3.5? Read that again if you have the copy.
Pardon, my lord. I have page 5.
Page 5 of the order.
My lord, I have.
Starts from the beginning.
Released in the week commencing from 24 to 2025, it is made clear that no adjournment will be granted on the next date of hearing. Till date and next date of hearing, appeals, petitions preferred by the accused victims will not be dismissed on the ground that delay cannot be condoned beyond 90 days. The High Courts may proceed with writ petitions challenging the provisions of the UAP 1967.
So therefore, UAPA Act, the provisions of challenging the provisions, not those provisions which have already been challenged before the Supreme Court and issue has been decided. These are some other things. How do we know that it is 43D5?
No, my lord, when your lordship will kindly see my application, which I placed before the Supreme Court, saying that my 43D5 application is pending.
Five times over, constitutionality of an act would not be discussed, no? So let's see Vatali whether it has the constitutional aspect has been dealt with or not.
My lord.
Vatali and K. Nazir. K. Nazir was only with respect to grant of bail because 4 years had passed by.
My lord.
But then nothing was considered except the period.
My lord.
So constitutionality, you have to perforce go to that decision of Vatali.
My lord.
We'll hear you on some other day. There's no urgency. Let this matter come up for consideration. Tell us, Mr. Counsel for the Union. Just tell us what is the status of the case challenging the validity of 43.5, if at all. Because I don't think they are going to take it up. Otherwise, they'll have to, the Supreme Court will have to constitute a larger bench, no?
Lordship.
It has been decided. Just have all the laws cleared and then come back to us on the next date. List this matter for consideration give a date after 30 days, for 4 weeks.
My lord.
2nd of September.
May I have the copy of the writ petition?
Yes. Item 16.
If you have an additional copy, let it remain here on the
Well,
record.
then I will give a photocopy right now. I will give a photocopy. Right. Yes. Okay. Your number? 16. This.
Yes, who appears? This is item number 16. Call out again.
This has already been decided in the division.
What is this?
I challenge to an provision of section 8(2) and 8(5). This one is, this is in fact reported, Monohar said. It's order 2253.
Nobody appears on behalf of the petitioner to press this petition. The counsel for the respondent, however, is present. Re-notify 8 weeks.
It's covered.
It has already been decided, my lord, petition.
Petitioner be here. We'll withdraw it. If on the next date it doesn't come, we'll dismiss it for
Default.
default. We don't want any unnecessary restoration petition.
18-9. Item 17 to 20.
My lord, the matter relates to granting of temporary status to these casual Mozdurs engaged by the PSL. My lord, there was an order by the CAT.
Chaudhary, just a minute.
Yes, my lord.
Just give me 1 minute.
My lord, I have prepared a list of dates.
Yes, yes, yes. So you have not come to the High Court, therefore you are not getting that status. Yes, you must be having a state policy, no?
My lord.
You appear for Bharat Sanchar Nigam.
My lord, I appear for
You
PSN.
appear for BSNL. Now, the state of Assam must be having a state legal policy, state, what is it? Litigation policy.
It's
That if-
the
if-
Union of India, my lord, BSNL.
BSN.
BSNL is all right,
Ah.
the state,
Ah.
and I'm asking for another thing. We understand it's Union of India. There is a litigation policy everywhere in every state. That if there is an order which has been sustained in the Supreme Court, there is no possibility of any curative petition. Therefore, similarly situated persons should not be asked to go to the court all over again. This only adds to the number of the cases. Fruitless exercise. Right, so what do you have to say to this? We have asked about litigation policy only for the purposes of letting you know that they were Mazdoors. They were granted a temporary status under a scheme. Later, the scheme was withdrawn for some reason or the other. The CAT also found that to be irregular. The High Court set aside the CAT's order. Several writ petitions were filed. Unfortunately, Mr. Chaudhary's clients did not file any writ petition, therefore he was not granted that status later. Now, would you want this court to pass an order?
Our stand, my lord, on the affidavit is that the judgment that the High Court has passed is a judgment in personam. It applied only to those petitioners because specifically the benefits for those petitioners were to be worked out.
Now, when had this happened? Now, this cannot remain open-ended for eternity.
My lord.
So therefore, this approach would be advisable, would be acceptable only if it is a very late kind of invocation of the right of the appellant or petitioner.
High Court order was of
Last of such petitions were filed when?
2016.
2016.
Last order is 17.
High Court decided on 15 June 2017.
Is there any stipulation in the SLP judgment
My lord.
that only petitioners here or before the High Court? Because in many cases they do that.
My lord.
When they are, especially when they are exercising their jurisdiction under Article 142 of the Constitution, they say that only those persons who are here would get the benefit, rest not.
My lord, page
That's a good
150.
demarcation.
On page 150, the court says that we are not inclined to interfere with
Page
the
150.
interim judgment passed by the High Court. Special petitions are dismissed, leaving all questions of law open.
There is no question of law here, no? It's a question of fact.
No.
You want us to pass an order, we'll pass an order. Unless you have some specific objection against this.
My lord, in fact, in item 18, I had actually advised my lord the BSNL that this kind of
Louder.
this kind of my lord persons in BSNL are there in different states. Around 3,000 such plus casual workers are there. So in view of the recent trend that has been followed by the apex court that post Tuma Devi, persons who still continue in casual engagement, something has to be worked out for them because they cannot be called casual employees if they are retained for another 10,
You are
15 years together.
thinking of giving them something more and denying something which they are entitled under the law. That beneficial thought, let it be translated first to give them the status of temporary Mazdoors.
My lord.
No dispute that they are the same. category.
Was the-
That is good. Just check that. You take reference of the judgment of the High Court. Only two judgments are there. We allow the petition. Yes, Mr. I'll answer the question. Mr.
My
Pathak, you
lord.
don't dispute that they are similarly situated. Only dispute is that they have not approached.
They had not approached my lord.
There is no dispute. Sir.
My lord.
That is what we want to.
That is one thing.
All right, then we allow this petition.
And the second issue that we have raised is that the order by which they were earlier conferred, my lord, which benefit was availed by the earlier set of persons, have been now withdrawn also,
No, that's right. That was withdrawn because of the decision to withdraw, no?
my lord.
But later you are giving it to everybody. That order of CAT also was set aside.
That was
It was set aside with respect to the not granting that status by others.
my lord.
So this stands decided that they are required because they would be the beneficiaries under that scheme.
My lord.
The scheme has not been withdrawn.
The scheme was, my lord, in Uma Devi, my lord, the scheme.
No, forget about Uma
If
Devi.
that's-
Don't remember Uma Devi. That's paragraph 58 is the controlling paragraph.
53, my lord.
53 or 54, 58. Now, there is no dispute that others, Tejpur has done, other places they have done. They were neither here, they had never approached the High Court, nor had they ever gone to Supreme Court. So that's the only question allowed.
18 would be slightly different, my lord. Item 18 would be slightly different, though it is involving similar issues, my lord. In item 18, they had approached the tribunal. The tribunal said,
We'll hear another day. First you write this, then we will see.
Look, in item 18, they also prayed for grant of temporary status, my lord. Since 1992, we are still continuing. Likewise, the petitioner in item 17, my lord. We are still continuing for more than 30 years, my lord. But till date, my lord, we haven't been granted the benefit of temporary status. That is our precise reason.
difference?
More than 30
the
years.
difference is that, my lord, in this matters, the High Court had earlier remanded back the matters to the tribunal, saying that you consider the evidence regarding their engagement. The tribunal, my lord, found that there is no evidence concretely proving their
But
engagement.
other people said only because of that they were in some criminal cases and acquitted.
My lord.
In this case, that decision is not yet that whether there are any evidence of that they are temporary.
My lord.
My lord, in fact, we produced documents before the, I'm sorry.
These cases, they are.
This is those things. Which are other items? What about item 19?
19 and 20 would be 17. 19, 20 would be same.
17, 19 and 20 we decide together,
My lord.
all allowed. 18 we'll hear on some other day. 18 we'll hear on some other day. Let this be decided.
My lord.
Item number 18, list this matter after 4 weeks.
My lord, may I pray for my lord, subject to permission, my lord, some of the persons they are going to attain the age of superannuation. May I pray for a fixed date if possible, not principle?
A difference. No, how does it make a difference?
Look, there is possibility. If I retire, then they come up with
Or
a
2
stand
weeks.
that you are not regularized,
We
will
are
not
keeping
be.
it after 2 weeks.
My lord.
Fine, my lord.
2 weeks we say, but the date would be given.
Fine, my lord. I'll take the
Yes.
date, my lord. Fine.
Item number 18. WPC number so and so. Bracket with item number 18 of today's cause list is being detached from the group of cases and is directed to be listed on your date after 2 weeks.
My lord.
19.8.
Fine. Deeply okay.
Item 21.
Yes.
May I please, your lordships?
This goes.
Your lordship, in this case, my lord, the petitioner herein, my lord,
Yes.
the petitioner herein, my lord, is not a borrower, guarantor, or mortgager of the property, my lord. With respect to the loans which were taken by respondent number 4 to 6, my lord. Sorry.
Loans were
important-
taken by respondent numbers 4 to 6.
4 to 6, my lord.
Yes.
Now, importantly, my lord, what had happened in 2010, my lord, a building permission was taken by respondent number 6 for construction of the building, my
Now
lord.
tell us about yourself.
Yes, my lord.
You are the purchaser.
I am the purchaser in the,
You are the purchaser after the bank had created the mortgage.
my lord, yes,
then-
that is a fact, my lord.
Then caveat emptor principle would apply.
My lord, the only difference, my lord, that there is a fraud which has been committed by the branch manager, my lord.
How come?
Yes,
Tell
my
us.
lord, that is there, my lord. In my additional affidavit, my lord, that was
Is it
filed,
coming for the first time?
my lord, it has been heard earlier, my lord.
Huh? Notices to Punjab National Bank?
Yes, sir.
You're here.
I appear for this.
All right. You have put in your response also?
No, we have not filed, my lord. It's basically upon the records before the DRT and DRAT, my lord.
No, file your
My
response.
lord, this,
Yeah, once fraud is alleged, you see, it can, see, a purchaser has a right if the purchase is by bank's consent, if the purchase has been made in public auction organized by SARFAESI, and if there is a fraud or collusion by the bank,
But
and if it is unregistered or something, then only these are the 4 cases. Otherwise, we would pin him down with caveat caveat emptor principle, he should have purchased the property with his eyes open. But he raises fraud. You put in your response.
No, I'll put in a short time, maybe allowed.
Take down. The petitioner is the purchaser of the property which has been proceeded against, against which proceeding has been initiated under the SARFAESI Act for the owner slash loanee of the house having defaulted in amortizing the loan. The contention of the petitioner is that he has been put to unnecessary trouble and that his interest has not been secured. He has further submitted that his cause of action arises because of the fraud slash collusion on the part of the bank authorities in proceeding against the house owner under section under the SARFAESI Act. The Punjab National Bank shall put in the written response to the petition by the next date. Re-notify which date?
Lords, after the 15th of August.
After 15th of August.
26A.
Deeply.
Thank you, my lord.
Yes.
Item 22.
May I please?
Yes.
This actually is preferred against the judgment passed by the Honorable Single Judge.
Yes.
This actually is preferred.
Louder, louder.
Preferred against the judgment passed by the Honorable Single Judge Lordship. Judgment is at page 154, Lordships. And relevant portion at page 160.
Let's see the impugned judgment.
157.
Judgment, relevant portion at para 7, Lordship. Here, Lordship, Honorable Single Judge had wrongly construed the minimum wages act, Lordship. We are doing purely research of, Lordship.
Yeah, yes. Just
Paragraph 7.
1 second.
1948 that she's talking about. That is, just this act of 1948. Just a minute. It should be mentioned. Minimum wages, they must go. Like, or industrial dispute. No, minimum wage. The
Minimum wage.
act was
Minimum minimum wage act and industrial dispute.
industrial, because who's a definition will come from industrial dispute. Like,
Industrial dispute act,
Industrial-
1947.
who's a. No, we'll say minimum wage act politically, huh? Part two. Guessing part one. Part two.
Search Institute. Let's see the. Where is the regional commissioner's order? Page?
Page lordship.
See, come करवा देना. AC.
120.
Page 120.
Yes, lordship.
For the authority under the Minimum Wages Act, the Regional Labor Commission. The answer is better here at page 124. These are proper and better than High Court. Okay. Again. Yeah. And the return integration is allowed at the side. Whatever is working necessary. When it is for the purpose of the implement. You can even perform the right to the present. Okay. There's a. What is the more advanced? When you're beginning to get my email, it's 10. Industry means any business, trade, undertaking, and it's an undertaking. Only the. By any means, they should be treated like the other. उनका देखेंगे जरा। Yes. Question. Ms. Bora,
Lordship.
you're appearing for the respondents.
For all the private response.
All right. क्या बहस करना बोलिए? We are dismissing your petition.
Lordship, but we are doing purely research work, Lordship, as per our Lordship CPCRI web function is defined at page 80, Lordship, page 79, Lordship. And Lordship, we are not doing any trade or business, Lordship. We are doing only research work, Lordship. We are not doing any trade or business, so it is not come under the purview of minimum wages act, Lordship. We are not fall under schedule 2 of part 2 of the schedule, Lordship, where it is defined, Lordship. Minimum
Take
wages.
Heard. Ms. R.B. Bora for the appellant and Mr. M.K. Sharma for the private respondents. the challenge in the present appeal is to the judgment passed by a learned single judge dated so and so, passed in WP's number so and so, whereby the prayer made on behalf of the appellant not to treat the private respondents as persons entitled for Minimum Wages Act was rejected. Minimum Wages Act 1948 was rejected. It appears from the records that the private respondents who are employed as skilled laborers by the Central Plantation Crops Research Institute, Kerala, having its research center at Kahikuchi, Guwahati. The private respondents were located at the research center at Kahikuchi. A proceeding was initiated by the private respondents before the regional commissioner before the Regional Labor Commissioners, Central (RLCC) Guwahati, seeking minimum wages, which was allowed. Hitherto, the respondents were being paid only 1,500 as stipend. By the order of the RLCC, the appellant herein was directed to deposit an amount of 18,49,335.78 plus 36,98,671.56 plus 55,48,007.34 in the form of a demand draft in favor of the authority under the Minimum Wages Act of 1948 for payment of wages to the respondents. This was challenged by the appellant before this court by writ petition bracket C613 of 2013, stating that the appellant herein is a research center and the respondents who were engaged on a stipend of who have been engaged on a stipend of 1,500 do not fall in the category of people under employment under either part 1 or part 2 of the schedule appended to the Minimum Wages Act 1948. Thus, it was contended that without the employment of the respondents to be either under part 1 or part 2 of the schedule, both the authority, both the RLCC, Guwahati, and the learned single judge erred in holding that the respondents were entitled to the minimum wages under the Act of 1948. In order to appreciate the contention of the appellant, it would only be apt to extract the part 2 of the schedule referred to above, which reads as hereunder within quotes likhna. I'll be telling you the propositions also, so therefore be very careful. Employment in agriculture, comma, that is to say, comma, in any form of farming, comma, including the cultivation and tillage of the soil, comma, dairy farming, comma, the production, comma, cultivation, comma, growing and harvesting of any agriculture or horticultural commodity, comma, the raising of livestock, comma, bees or poultry, comma, and any practice performed by a farmer on a farm as incidental to or in conjunction with farm operations, bracket, including any forestry or timbering operations and the preparation for market and delivery to storage or to market or to carriage for transportation to market of farm produce. The contention of the appellant herein is that unless the produce is taken to the market for storage or for delivery, comma, any other work on the farm would not fall in the category of employment in agriculture. This contention was repelled by the learned single judge, and rightly so, on the ground of the absurdity creeping in if in the last part of part 2, the word and is to be treated, word and would be treated as conjunctive. Conjunctive. A plain reading of part 2 of the schedule to Minimum Wages Act 1948 would indicate that all employment including farming, cultivation, tillage, dairy farming, of agricultural or horticultural commodity, comma, raising of livestock, poultry, etc., would form part of the Schedule 2. Stop. If the incidental or conjunctive farm operations like forestry or timbering operations and the market and the preparation for market and delivery to storage or to market or to carriage for transportation to market of farm produce is required, comma, that shall also form part of the schedule. Thus, the word and does not control the other definition of employment in agriculture, and it would not be necessary at all to test whether a person falls in the category of falls in Schedule 2 by testing whether the produce is taken to the market for storage or delivery. Full stop. Even on this count, comma, the contention of the respondents is that as part of the research center, comma, the respondents grow crops, which obviously is done after working in the fields, and which produce is taken to the market. Full stop. Even if it had not been taken to the market, comma, the respondents would have fallen in the category of part 2 of the employment for which Minimum Wages Act 1948 applies. Full stop. The appellant has tried to put an extra gloss over the wordings in part 2 of this schedule, so as to mean that unless the agricultural produce is taken to the market for storage or for delivery, comma, it would not fall in the requisite category for the application of Minimum Wages Act 1948. This requirement is with respect to incidental operations connected with farm operations, and in that case, even persons who are working for transportation or preparation for transportation or are involved in carriage of the produce to the market would form part of that category. By any explanation to the definition, comma, the respondents fall part of the respondents fall in the category of employees defined under part 2 to the schedule of the Minimum Wages Act. With this, this court therefore finds that for right reasons, the RLCC, as also the learned single judge, repelled the contentions of the appellant. There is no merit in this appeal and is therefore dismissed.
Deeply obliged.
Obliged.